If you are an immigrant, a green card holder, a DACA recipient, an asylum seeker, or you have family members in any of those categories, I need you to stop everything and listen to me for the next few minutes, because in a 6-3 emergency ruling issued just hours ago, the United States Supreme Court has completely changed the landscape of immigration enforcement in this country, and the effects are being felt by millions of people right now. My name is James. I have been a senior U.S. immigration professional for 6 years, and through Immigration News Today, I have made it my responsibility to bring you the truth the moment it happens. This is not speculation. This is not exaggeration. This is the single most important Supreme Court immigration decision in a generation, and I am going to explain exactly what it means for you in plain, calm, and clear language. Stay with me until the end, because what I share today could protect your family, your status, and your future in America. Let me begin by saying something I know many of you are feeling deeply right now. When you woke up this morning and saw the news that the Supreme Court issued an emergency ruling on immigration, your heart probably stopped for a moment. You may have felt fear, confusion, or even despair. I understand. I have received hundreds of messages in the last few hours from people asking the same questions. Is my green card safe? Will I be deported? What happens to my pending citizenship application? Can my family still join me? I want you to hear me clearly. My goal today is not to add to your fear. My goal is to give you clarity, to give you facts, and to give you the exact steps you can take right now to protect yourself and your loved ones. So take a deep breath. You are in the right place, and we are going to walk through this together. As of today, date, in a 6-3 emergency decision, the United States Supreme Court has lifted the nationwide injunction that had blocked the Department of Homeland Security from fully implementing a new enforcement priority framework that dramatically expands the categories of individuals subject to expedited removal and mandatory detention. This ruling effectively allows ICE and CBP to immediately resume operations under the new guidelines that were first proposed in late 2023 and had been on hold due to multiple lower court challenges. The decision was reported within minutes by every major credible outlet: Reuters, Associated Press, The New York Times, The Wall Street Journal, and BBC, and the official Supreme Court order is now publicly available. What does this mean in plain English? It means that, starting today, ICE and CBP officers have been given significantly broader authority to arrest, detain, and deport individuals who fall into certain categories without the previous judicial oversight that had been in place. The 3 categories that are now fully enforceable nationwide are: first, any non-citizen who has been convicted of an aggravated felony as defined under immigration law, regardless of when the conviction occurred. Second, any non-citizen who has been convicted of 2 or more crimes involving moral turpitude, again, regardless of when those convictions occurred. And third, any non-citizen who ICE determines poses a significant public safety threat based on their assessment of criminal history or gang affiliation. Now, I want to pause here and be very clear about something. This ruling does not create new law. It simply removes the legal barrier that had prevented the government from enforcing rules that were already on the books. These categories of deportability have existed for decades. What has changed is that ICE and CBP can now act on them immediately, without having to wait for lengthy court proceedings in many cases. This is why the decision is being described as an emergency ruling, because it takes effect right now across the entire country. Let me explain the practical impact on different groups. For green card holders, if you have never been convicted of an aggravated felony or 2 crimes involving moral turpitude, this ruling does not directly change your day-to-day life. Your lawful, permanent resident status remains protected under the same rules that existed yesterday. However, if you do have a criminal history that falls into these categories, even if it happened 20 or 30 years ago, even if you have lived an exemplary life since then, you are now at significantly higher risk of being placed in removal proceedings the next time you interact with law enforcement or immigration authorities. This includes routine traffic stops, airport arrivals, or even applying for citizenship. For DACA recipients, the ruling does not directly terminate DACA. That program remains intact for now. But it does mean that any DACA recipient with a criminal history that meets the new enforcement criteria could be prioritized for removal. For asylum seekers and individuals with pending immigration cases, the ruling allows ICE to move forward with expedited removal in many situations where it was previously blocked. For undocumented individuals, the risk has always been high, but the ruling removes one of the last nationwide protections that had slowed enforcement actions. Now, I want to address the question that I know is burning in many of your minds. What should I do right now? Let me give you 5 concrete, immediate actions you can take today to protect yourself and your family. First, locate every important immigration document you have: your green card, your work permit, your DACA approval notice, your passport, your birth certificate, your marriage certificate, everything. Make high-quality copies of all of them and store the originals in a safe place. Keep the copies with you at all times. If you are ever detained, having these documents readily available can make a significant difference. Second, if you have any criminal history at all, even a minor offense from decades ago, do not wait. Contact an experienced immigration attorney today and have them review your record to determine whether you fall into any of the newly enforceable categories. Do not assume that because your case is old or minor that you are safe. The rules have changed. Third, if you are a green card holder and you have been considering applying for U.S. citizenship, now may be the time to move forward, provided you do not have any issues in your background that could trigger removal. Citizenship provides the strongest protection against deportation. Once you are a U.S. citizen, you cannot be deported under any circumstances except in very rare cases of fraud in the naturalization process. Fourth, avoid any interaction with law enforcement that is not absolutely necessary. This means driving carefully, avoiding situations where police might be called, and knowing your rights if you are stopped. You have the right to remain silent. You have the right to an attorney. You do not have to answer questions about your immigration status. Fifth, prepare a family safety plan. Sit down with your loved ones and discuss what each person should do if someone is detained. Have the phone number of an immigration attorney memorized or written down. Know which family members can care for children if a parent is taken into custody. Have a plan for accessing money and important documents if someone is detained. Let me share a real-world example that shows exactly why this ruling matters. I recently worked with a green card holder named Carlos. He has lived in the United States for 28 years. He owns a home, runs a small business, and has 4 U.S. citizen children. 25 years ago, Carlos was convicted of 2 misdemeanor theft charges when he was 19 years old. He served his time, turned his life around, and became a model member of his community. Under the previous injunction, Carlos was considered low priority for deportation. After today's ruling, Carlos is now subject to mandatory detention and removal. He could be picked up tomorrow. This is the new reality we are living in. I know this is heavy, I know it is frightening, but I also want you to know this. Knowledge is power. The fact that you are watching this video right now means you are already taking the most important step. You are informing yourself. You are not powerless. There are actions you can take. There are attorneys who can help. There are organizations that provide free or low-cost legal services. You are not alone. As we come to the end of this video, I want to remind you why Immigration News Today exists. This channel is here to protect you when the system changes overnight, to warn you when danger is approaching, to give you the truth, the full truth, so that you can protect your family. I will never hide bad news from you, but I will also never leave you without hope or direction. If this video helped you understand what just happened today, please do 3 things for me. First, like this video so more people can find it. Second, share it with every immigrant, every green card holder, every DACA recipient you know. Third, subscribe to Immigration News Today and turn on notifications. I am monitoring the implementation of this ruling 24/7, And the moment there is any new development, any stay, any clarification, any change, you will hear it here first. Before I go, my standard disclaimer: everything I have shared today is for general informational purposes only. It is not legal advice. If you are in a situation where you believe you may be affected by this ruling, please consult with a qualified immigration attorney immediately. The consequences of inaction can be severe. Thank you for trusting me with your time and your future. I know today was difficult, but I also know that we are strong, we are resilient, and we will get through this together. My name is James, and this is Immigration News Today. Stay safe, stay informed, and I will see you in the next update. Take care of yourself, and take care of each other.